Welcome to the latest Evershed Sutherland Legal Insights podcast.
Hello, and welcome to Conversations in Credit, the podcast where we look at the latest developments and insights in the world of consumer credit. I'm your host, Alexandra Byard, a senior associate at Evershed Sutherland, and today I'm going to run through the Treasury Consumer Credit Act 1974 CCA reform, phase 1 consultation, and what it means for consumers and firms alike. We have released a flash briefing already in relation to this, and this podcast is based on that flash briefing, if you prefer the podcast format for your current awareness. So, Treasury CCA reform responses are required by 21st of July this year. And to modernise regulation, the government intends to introduce more flexible consumer credit rules to shake up the market, making it easier for consumers and firms to navigate. Their consultation paper provides an update on the government's detailed proposals for phased reform of the CCA. And the major points to take away from the paper, there's a proposal to scrap the prescriptive information requirements. So the first consultation on CCA reform found that current information requirements do not promote the best customer outcomes. And it was found that the information can be quite complex and confusing, sometimes meaning too much information is being provided with negative mental health impacts. There's also that lack of flexibility, which is quite frustrating for innovation, and particularly in the utilisation of technology. HMT's intention is to repeal all of the information provisions in the CCA and accompanying regulations, and for these to be recast into the FCA rules. The FCA will also consult in due course on changes to its rulebook and will consider as part of that to what extent any specific information disclosure requirements are needed. Another point to take away from the paper is the repeal of many CCA provisions, and that's looking at whether FCA rules or other protections from as part of the FISMA regime could provide for a similar outcome as is provided in the CCA. And where it cannot, then HMT will consider whether the absence of the CCA provision would mean that consumers would not have robust consumer protection. And where that's the case, HMT will look to retain the provision in legislation or modify it as appropriate. Where a provision is retained or modified in legislation, HMT will look at the intended outcome of the provision, and the new requirements will reflect this but may apply in a different way. Another area is technical matters. So we've got the repeal of the small agreements provision. So small agreements are those agreements for credit not exceeding £50. So other than a hire purchase or conditional sale agreement, HMT propose repeal of those provisions and for the FCA to then consult as to whether and how its rules should apply to such agreements. The repeal of modifying agreements provision. So HMT propose repeal of these on the basis that they cause a lot of unnecessary complexity, which makes it difficult for firms and consumers to agree changes to agreements. The FCA can consult on any further changes it may consider necessary to its rules. We've got the repeal of multiple agreements provision. So this is where a single credit agreement covers more than one type of credit or financial arrangement. HMT found that current provisions are complex and hard to comply with, leading to documentation that is unclear or difficult for consumers to understand. The FCA can consult on further changes it may consider necessary to its rules. Electronic disclosure. So HMT proposed repeal of Section 176A, stating that it lacks flexibility. So the FCA will consider this and consult on any necessary changes to its rules. Finally, gone away consumers. HMT recognised that there are concerns around the ongoing obligations to provide communications to customers when firms know the customer no longer resides at their last known address. So HMT proposes to repeal the majority of the information disclosure requirements, which will then enable the FCA to consider the issue of gonaways and consult on changes to its rules in relation to those sorts of customers. In terms of sanctions, HMT have considered the sanctions provided by the CCA on firms for non-compliance with CCA provisions. They state that there is no evidence that retaining such sanctions would provide protections to consumers beyond that already offered to them by FOS, so the Financial Ombudsman Service, the FCA regime, Consumer Duty, or the usual court processes. HMT also concludes that it is no longer necessary or appropriate to include a set of sanctions that is designed to be deliberately punitive and not commensurate with the level of harm suffered by consumers. HMT also considered sanctions are not compatible with proportionate regulation, and as such, HMT intend to remove the sanctions regime, which will then bring consumer credit in line with other financial services. In terms of criminal offences, there are some CCA provisions which do give rise to criminal offences. The FCA's view is that criminal offence in the CCA are no longer needed, given the FSMA regulatory toolkit, which includes the senior managers regime. The FCA could provide additional rules for authorised firms where appropriate, prohibiting each of the activities targeted by the existing criminal offences. HMT review of the existing offences revealed little to no use of such offences in practice. There's also the HMT states that criminal offences may be inconsistent with the approach taken in modern financial services regulation. However, there may be value in retaining some of them to serve as a strong deterrent against harmful business practices. HMT have asked for views from readers. So looking ahead to phase 2. Phase 2 consultation will explore rights and protections as well as key definitions and the scope of consumer credit regulation. It will also consider cross-cutting themes. So these include Islamic finance, so how a reformed consumer credit regime could remove barriers to enable Sharia-compliant finance to be offered by firms. Green finance, so how CCA reform can help support the rollout of green finance products. Technology, how reform can support future-proof and enable developments in technology to facilitate innovation. And public sector equality duty, so how reform will impact people with protected characteristics. A list of the proposed CCA provisions to be repealed is set out in Annex B to that consultation paper. So thank you for tuning in to Conversations in Credit. If you have any questions or queries about today's topic or any other consumer credit issues, please don't hesitate to get in touch. There will be a separate flash briefing and podcast on the BMP proposals, which have also been released. So we look forward to hearing from you and continuing the conversation.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.